Hey, what's up? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, this is a very, very important video. Not to say that my other ones are not important, but this one kind of goes into what I get from a lot of people, and it's because they're under heavy emotional stress when it comes to debt and dealing with debt collectors, getting sued by debt collectors. And I decided to make this video because I had spoke with someone today, really a couple of people today that are facing uh, potential judgments, and they kept saying one thing, and then they were thinking another thing, and so I want to make this video to kind of help people to kind of focus in on what they really want because um, I kept going back and forth with this person about what do you really want? You're saying one thing, but it sounds like you're thinking something else. And so, before I get to that, though, I want to talk about the debt that's being released on the market. You got to be careful. These companies are about to really put a full court press on going after people, and they're even using the laws to make it even tougher for people. They're going around to different states and they're getting legislation on if you owe creditors or specific types of creditors, where they can have your driver's license um, uh, uh, voided or whatever they call it. Have your driver's license where you don't have a valid driver's license. They're threatening people if they have government jobs or jobs that are getting some type of government contract money, where they're threatening that they're going to get a judgment, and that's going to force the company to fire that individual. So this is very serious. This is why I always say whenever you get any letter, it doesn't matter how much it is or whatever it is, you need to go through the process of trying to stop it from moving forward. And I'm going to tell you at the end of this video some of the things that you can do to stop collections that are coming through. But if they are coming, I'm going to tell you how you need to be able to deal with them also. So you're going to want to stay tuned with this video. So first, what I want to go through is the debt that's being sold on the market. This is major credit card debt, over $3.3 million worth of old credit card debt. Charge-off date is 2000 to 2009. Average balance $677. There's another group here, $5 million worth of credit card debt, 4,700 accounts. Charge-off date 2008 to 2010. Average balance $1,062. Another group here is $13 million. Mixed major credit cards, um, uh, jewelry store, also department store credit cards. Average balance $689. $13.5 million, 2010 to 2013 is a charge-off date on those. Another group, major credit card, major banks, 3.5 million, charge-off date 2009, 2010, $2,421 is the average balance. They're actually selling that whole portfolio for just $1,000 over what their average balance is. That means that if out of the 1,446 people, if two people fall for it and pay the debt, and this is debt that in most states is not valid to even have to pay. But if two people out of 1,446 people, they will already be in the profit. So you can see why these companies will take the risk on doing this with debt that is past legal statute of limitation. There's another group, um, major credit card, major banks, national banks, 1,986 accounts, $3 million, charge-off date 2009 to 2010, $1,510, 93 cents is the average account balance. And they're selling this debt if they get two and a quarter people to pay, they're going to break even on what they're selling this whole $3 million portfolio for. Here's another one here, um, $69.1 million charge-off date, 2000 to 2015, major banks, major United States credit card providing banks. Average balance $6,471. They did not put the price on there that they're willing to sell it for, but I guarantee you it'll probably be somewhere either double that or even under that. Here's another one here for $8 million. 2000 to 2009 charge off dates. Uh, Average balance $1,911. Selling that whole portfolio for $8,000. All you need is 8 people out of 4,185 to pay, and they break even. So you can see why they're willing to do that. Another one here, 6,863 accounts, major credit cards, banks, and payday loans, and cell phone companies mixed into here. This is a special one. Haven't seen much of this with cell phone companies. Again, with cell phone companies, because their communications, there's only a 2-year statute of limitations on those. So they can't just come after you the same way that it would be for like a regular debt, because they had that 2-year statute of limitations on them. So always watch out for when you get something from an old cell phone or some type of like if you had cable bill, any of those. It's 2-year statute of limitations, the federal statute of limitations on those types of debts. That's why they sell them off really quick, because they just try to get what they can get for them, and try to leave it up to a debt collection company to try to collect money on it. So let's see if there's any more. I haven't been able to make as many videos as I wanted, but I wanted to go over some of these here. I think this one was one that I just mentioned. I get these all the time. Let's just make sure. So yeah, the same one, 44.9 million. Yeah, same one. So first, before we move on the video, let's go through what the process. You're going to get a demand letter from these debt collectors. These are going to be third-party debt collectors, not the original creditors. Whenever you get that letter, you should automatically send a cease and desist letter to them after you do this first step. First step is you need to see if it's past the legal statute of limitations. And if it is past legal statute of limitations, and you can check that on my YouTube channel, I made a video. You can type statute of limitations. I did a video state by state, all in order. Or you can go to my website, thecreditrepairshop.com, and search on my blog for statute of limitations. You can see state by state. Um, if it's past the legal statute of limitations to collect, you don't need to argue about the debt. You don't need to say anything about your job or none of that stuff. You just need to give them a letter notifying them, and you should send it certified mail, stating that this they're trying to come after you for a debt that they legally cannot have you that they cannot legally collect, but they'll use words like you have a moral obligation. Even if they call you and they say you have a moral obligation, not a legal obligation, they will actually say that on the phone. Some people don't believe me, but that they actually have a recording for debt collectors that only deal with debt that's past legal statute of limitations to collect. They actually have it in their recording that you only have a moral obligation, that you have no legal, or they'll say that they cannot sue you over it, but you have a moral obligation to pay it. Um, Regardless of how they put it, if you check and it's past legal statute of limitations, all you have to do is notify them that they need to stop all collection activities. I give you that letter for free. The link is below this video. You can get that letter, send it to them, send it certified mail. Just fill in the blanks what you need. Next thing is, if it's not past legal statute of limitations, send them a cease and desist all collection activities letter, because this is a third party debt collector. There are certain things that they're not able to get from the original creditor, and some debt collection companies don't want to risk it, especially when you send this letter. This letter kind of puts them back on their heels, and they have to make a decision if they're going to try to come after you for it, because they don't expect you to either know or ask these types of questions that I'm giving you to in that letter. That letter is free to load here. If it's not past statute of limitations, send that letter first and then let them respond. Some of the times they're going to respond saying that they're not going to come after you. Other times they might try to send you some stuff, and then you need to send the third letter that I have that is also attached to the statute of limitations letter is a debt validation letter. Send that letter after you read their response from the cease and desist letter. They might say that they're not going to come after you. If they send some stuff back saying, yes, this is you, you need to send the debt validation letter and see what responses come back from that. Now, let's get into that email that I got. I'm not going to mention the person's name, but they're being sued by a debt collector. And their goal, the main goal, which is something that I always tell people to, uh, to understand themselves before even proceeding with doing stuff, is if your goal is not to get a judgment, you have a collection agency coming at you, you've done the things that I've told you to do, and they're still coming after you, and you don't want to get a judgment. These are your options. You have to evaluate, number one, your personal situation. And I'm talking about this one here because this individual obviously did not do the things that I just told you to do before, because it could really have already been resolved. But we're talking about people, which is probably most of you, you missed the certain processes that I just talked about, and they are trying to come after you for the money. You have to make a determination on what your goal is. Is your goal not to get a judgment, or is your goal to fight it? Because when I read and I talk to people, and with the consultation that I had earlier today, this individual was saying one thing, but they were thinking another thing. What they were saying is that they did not want to have a judgment. But what they were thinking is they were thinking, I want to fight this. And that it was kind of crazy. It was like I was talking to two different people when I was talking to them on the phone, and I was trying to get them to focus on what they were actually saying. Because if your goal is not to have a judgment placed on your credit reports, I mean a judgment placed against you on your person, public records, then the focus needs to be on coming up with the money and then making a settlement offer to them, because that's where, if you've checked everything, you've done everything, you've responded to the court summons, you know that this is going to be a debt that you're more than likely going to have to pay and that you're going to lose when you go to court, then you don't want, and you're trying to avoid the judgment, because when you fight in court with doing a summons response, you still have the chance of losing, and you have to accept losing if you're going to fight. You can accept winning, and you also have to accept losing. That's with everything. When you play sports, you do anything, you have to accept that you can win and lose. So I try to get people to focus and have their mind and their thought process, what they're saying and what they're thinking, meet each other so they can have one goal. So with this individual, they stated that, and this is another thing too, if you are not employed, you are not gainfully employed where they can check and see that you're employed, you need to notify any debt collector of that, because they might cease the collections of what they're doing. If you're on any unemployment, if you're disabled, any type of financial hardship, you should call them up and notify them directly. They might put your lawsuit on hold. But now, even if they don't, and you do not want to have a judgment placed on your personal record because of whatever reason, then the next thing to start focusing on is not to fight the judgment, because if you're trying to fight the judgment, how are you going to fight against something when you're trying to settle it? It just doesn't make any sense. Your focus needs to be changed on how can I settle it? And the straightest line to start and to settle that debt is to call up that collector, and you start opening up a dialogue on, number one, that you had a hardship, and that, or that you still have a hardship, but you want to avoid getting a judgment placed on you, and you are going to figure out a way to come up with a certain amount of money, and you would like to offer that to them. I always like for people to look at what they owe, split it in half, and then go back that off. So if you owe them $2,000, if you know you can come up with $1,000, first offer that you offer to them is $500. You know that they're getting this for pennies on the dollar, but what they're trying to do is to maximize their profits. Now, let me tell you how they're thinking. This is the thought process of a debt collector. Number one, if you never answer them, you never tell them your situation, they're going to look at your credit reports and they're going to try to base what you're going through off of your credit reports. They have access to TransUnion, Equifax, and Experian. There's a tracer application that all debt collectors and business owners can get a membership, and they can look at how you're living your life without running your credit. They can do this like doing a background check on you. And when they look at if you're making payments somewhere, you're making car payments, you're doing anything, they're going to immediately think that you're just hiding the money from them. So you need to open up the communications with them and tell them what you're going through, and then try to do a settlement with them. Again, with my example, you owe $2,000. If you can come up with $1,000, then you need to offer them $500 and go back and forth from there. Uh, Now, what they'll try to do is they'll try to say, well, if you can't pay, come to an agreement, maybe they come to $1,200 and you can't pay it all, maybe they'll let you make payments on the other amount. But they might try to say, well, if we have to wait for the money, then we're going to want all of the money. Set up a payment arrangement for all the money. And the reason why they'll do that is because they know if they go to court and win, that they can get a judgment and get that plus some court fees and some attorney's fees and interest stacked on top of it. So if you're trying to avoid getting a judgment, it's two things. I want to make it clear. You don't want to get a judgment placed on you because of your job or because of any reason. Some people just don't want the judgment. Then you need to start focusing on a settlement. Forget the other stuff. Now, and I'm also saying this if you've already passed the other processes that I told you to do at the beginning of the video. Now, if you want to fight the collection with the third party debt collector, your options that you have available for you, which is some things that they're not going to expect you to know that you have a right to get. Number one, when they send you the packet, it's going to have some old statements. It's going to have an affidavit from the original creditor saying that, or usually from another debt collector who bought it and then sold it to another debt collector. They're going to say that they looked at the books and all this type of stuff. I'm not even going to mention some of the stuff on there because this is the way that we've been winning in helping our clients. And I don't want a debt collector sitting here watching my videos and making it easy for them to flip around what they're doing to fight this stuff. But what we do is we turn around everything that I know from doing this business for all of these years, about to go into 17 years, 18 years, is that, and with my own personal stuff that I went through, is that there's certain information that that a debt collector cannot get because when the original creditor sells those portfolios, they don't care at all about the debt collector. They're going to give them everything at that time, and they tell them, don't bother us at all. You cannot come back and get anything. So now, if you're going to fight, this is what's going to be the fight. You're going to have the debt collector getting everything that they got from the original creditor. But there's certain things that they're not able to get. And a few of those is they're not able to get the true accounting of your true accounting records of your payments and all of the credits and interest charges, all of that stuff, and signatures. They're not going to be able to get that. They're going to have some statements, and those statements are going to be redacted. And on those redacted statements, you have a logical defense, to say that I need to have this stuff unredacted and I need to have everything that they're claiming to come up to this amount that they're claiming that I owe. you have a right to get all of that stuff. And there's other things. You can read your court summons to see how you can break that down, because that's what we do. And now, but you still, regardless, it's just like any court case. You see this all the time. So I'm not telling you anything new. But what happens is when you're the person that's in that seat, that defendant seat, it just seems like it's a whole new game. Is that you can win and you can lose. And that's something that's really beyond your control, because whatever is submitted, that judge is going to make a determination if they believe that the debt collector should win or if you should win. From what I've seen, my own personal experience, when you draw this out and you do the summons response correctly, and you make them have to get certain information, it's going to do one or two things. They're going to either dismiss it, they're either, or three things. They're going to either ask for a delay, or they're going to call you up and say, hey, let's just try to settle this. And so you've done, that means that you've done your work, you've done your part. Now they're like in a different mode for your account, not for other people. They're in a different mode for your account. So this is what you got to do, and you have to be clear. You have to have that understanding. I tell everyone when I'm working with them, you got to have that understanding. You could lose, and are you willing to accept the consequences if you lose? And the other thing about it is that before you lose, there is an opportunity for you to settle, but you have to be prepared. You have to have the, you have to have the temperament to go through that whole process, because they're going to drag you out. They're going to say all types of things. They're going to try to scare you. They're going to try to do all types of things. And it takes a special individual to actually go through all of that stuff, that process, and to make them have to prove everything. And then when they prove everything, if they do, to be that individual that will say, okay, give me a few minutes to see what we can work out. I did that. This is something that I did. This is how I learned how to do this. Lawyers, this individual right here in this email, this is what they said. I'm going to skip the stuff, but they said that they're being sued. I'm unfortunately being sued by, and they said a debt collector in their state. And they said, I've talked to a few lawyers, but I have gotten varying and at times horrible advice, and that they found my video. And the reason why they wanted to reach out to me is because I'm telling you the truth. Not to say that those attorneys didn't tell you the truth, just that they don't want to be bothered with you with your debt. It doesn't matter. They don't want to be bothered with you. I'm telling you the straight up truth. You can call any attorney right now and tell them you're being sued. They're either going to say call a bankruptcy attorney if they're not a bankruptcy attorney. And if they're a bankruptcy attorney, they're going to try to get you to file bankruptcy. They don't want to talk about no debt settlement and all that type of stuff. They don't want to talk about it. They want it to be easy. They're not going to go and look up the laws and try to flip around the court summons and do the response and all. They don't have time to sit there and do that. And as a matter of fact, a lot of them don't even want to get involved with it, because what it usually comes down to is you have to end up paying the debt, and then you're gonna have to pay that attorney $2,500, and then you got to pay the debt that may not even be $2,500. So I'm just telling you straight up, uh, there's very few attorneys that even deal with this. It's like, I would even say for the whole country, there's only probably about 10 firms that even fight and try to get lawsuits against debt collectors. It's not a lot. You can search it online. And even if they work with you, they're trying to find violations. Most debt collectors, I'm just going to tell you straight up, most debt collectors don't make violations. What they mainly do is they just don't have all the information. And just because they don't have all the information doesn't mean that it's a violation for them trying to collect the debt from you. Because if you don't know the questions to ask them, how did they violate anything? How did they omit anything? They just gave all the information that they had. So stop chasing around and thinking that there's some fast food way out of all of this mess. It's going to take work. It doesn't matter who you get to do it. Either you're going to do it and it's going to take work, and it's going to take patience, and it's going to take temperament. It's going to take dealing with frustration. Or if you, and that's if you have somebody else even do it for you. It's still going to be some work and frustration on your part. But if you have the temperament to stick through it, that's how stuff gets done. That's how stuff gets resolved. And no one, not me, no one can tell you how it's going to get resolved in the end. I've had accounts with people that owed $10,000 and got settled for $1,000. I had them that had $10,000 got settled for 2,000 or 5,000, and I've had some that had to go all the way with the $10,000. And that's going to come down to your circumstances. It's going to come down to your personal assets if it depends on what type of account it is. Is it a business account where they know you have assets? You had a business loan and you had trucks. Like one a client he got like 6 or 7 18-wheelers. Do you think that a debt collection company that knows you have 6 or 7 18-wheelers that are paid off is going to just walk away from a credit card debt that you owe? Do you think that they're going to do that, or do you think that they're going to try to take you all the way to court and attach your assets? That's what I'm saying. Understand where you're at, understand what the goal is, and then make that plan. And then that's the one that you focus on, and stop thinking two different ways to fight something where one of the ways that you're thinking or one of the ways that you're saying is not going to get you to that solution. Get your thinking and get what you're saying pointed in the same direction. And that's how you're going to get stuff accomplished. All right, I'm going to end the video here. Um, if you need help with your credit, please visit us at thecreditrepairshop.com. Links is below this video. Watch the video, what makes us different. If you can follow our process, we want you as a customer. If you can't, please choose someone else. If you need your credit reports and scores, because you're going to need to get paid credit reports from a paid monitoring service so you can look at the comments and look at when that charge off date was, because that's when the statute of limitation clock starts to tick. So you need it. The free places don't give you that. Spend some time and a little bit of money so you don't have to spend a lot of money in the end if it's something that's past legal statute of limitation. And as an individual, you need to know everything about what's on your credit report. Don't be fooled by people in these companies trying to get you to get these free services so they can sell you all types of stuff. Get it so you can know your information on all three reports and all three scores. I invite you to go to the number 3scores.com to get that information. Now, the free letters are also below here. If you need the cease and desist collection activities letter, if you need the debt validation letter, if you need the statute of limitations letter. The statute of limitations letter and the debt validation letter, they come in the same email, but it's two different letters. You don't send both of them. Cease and desist letter is on its own. It was just when I had put it together, I had my programmer do it that way. Uh, the link is below here. You fill out the information, a form, and then it'll come right to you. All right. Well, I appreciate your time. This is Stephen A. Williams, President and founder of thecreditrepairshop.com. Thank you for your time.